and progress. Hello, everyone, and welcome to the last episode of the series of webinars of 2022, entitled AI Talks at ETUI. My name is Aida Ponce del Castillo. I am a senior researcher at the Foresight Unit, and I am very happy to be your host. Today, we have a special guest, Professor María Luz Rodríguez Fernández. Welcome, María Luz. Maria Luz, or Luz for the friends, she's a professor of labor law at the University of Castilla-La Mancha in Spain. In her last year, she has worked as a senior specialist in labor market institutions at the ILO in Geneva, that's the International Labor Organization. And she has drafted the report for the expert meeting on decent work in the platform economy, which was done in October 2022. Maria Luz, she has a lot of experience at the Spanish level, at the European level, but also at the international level. And she's considered as one of the leading experts on the impact of technology on work. She has published 2 books in Spanish. The first one is Plataformas digitales y mercado del trabajo, or digital labor platforms are labor market. That was published in 2019, and Humans and Robots, or Humanos y Robots, in 2020. Moreover, we had the pleasure to have Maria Luz for 1 month at ETUI in our premises in 2017 as a researcher exploring the issues of digitalizations in the EU. So today we have Maria Luz to speak about the experiences of AI systems or algorithms in the Spanish context. We have a starting point, AI and labor. So our first question to you, Maria Luz, what has been the Spanish contribution to negotiating what we call AI? Please.
Good afternoon, Aida. Good afternoon, everyone. It is a real pleasure for me to talk to you about the Spanish collective bargaining experience on algorithms and artificial intelligence. And so many thanks, Aida, and many thanks to the European Trade Union Institute for this invitation for be with all of you. Okay. First of all, I would like to explain to our listeners the context in which collective bargaining experiences on artificial intelligence are taking place in Spain. This context has been the regulation of platform work and algorithmic transparency, and this has been done in a law, Law 12/2021, the so-called rider law. We speak about our rider law. And the most important thing for me is that this regulation comes from social dialogue. I would like to highlight this. A very important regulation of platform work and algorithmic transparency came from social dialogue. And this means that in Spain, the regulation of platform work and algorithmic transparency has been the result of an agreement between trade unions and employers associations. And as far as I know, this is something that has not happened in any other country in Europe and around the world. For me, the Spanish experience shows how the major challenge posed by artificial intelligence and algorithms in the world of work can be addressed through social dialogue. And I think this is a very important lesson from the Spanish experience.
Thank you, Maria Luz. And tell us a little bit about these negotiations. It came from social dialogue, it came from social partners, workers, and employers' representatives. What drove them to make this agreement, one, and what were the major difficulties in achieving this law and agreements?
Good. I think that the driver of this social dialogue was not the digitalization of our economic or digitalization of our labor market. It was the pandemic. It was the COVID. It was the health crisis during 2020-21. In Spain, I don't know if you know this experience, but in Spain, all the measures adopted to address this pandemic, the results of this pandemic on the labor market were adopted in the social dialogue. It was a very important experience of social dialogue in Spain. So the law about platform work and transparent algorithmic transparency was one of the pieces or one of the steps of this social dialogue. I think that without COVID, without this experience, very important experience of the COVID social dialogue in Spain, it was really difficult to reach an agreement on these important issues in my country. And I think that this is the difference between Spain and the European Union. Spain has a law and has a very important experience about platform work and algorithmic transparency. And at this moment, in the European Union, the things are not so well in both aspects. So this is for me the most important driver for this regulation. And what was the main difficult point? As the motivation of the law, the rider law itself acknowledged, the main problems came from technical issues. And this is very important, technical issues. We should bear in mind that even if the use of algorithms and artificial intelligence is becoming more and more common by companies, trade unions and employers associations are not used to dealing with these issues in the collective bargaining of the social dialogue. So it's not easy for workers and their representatives and employers and their representatives to address this kind of issues are really, really difficult. They have been outside of the scope of the industrial relations until now. So often, in addition to the difficulties to any social dialogue and collective bargaining process, there are now technical difficulties, because it's really difficult to speak about, I don't know, speak about data, rules of algorithmic transparency, all of these things for people who speak usually about salary, about working time, and now they have to speak about these new things, and they need to reach an agreement about these difficult issues. So, and this is my opinion. At this moment, it's crucial, really crucial to train trade unions and employers organizations and employers in this kind of matters, because if we don't train trade unions and employers organizations about all these very complex issues, it is really difficult to reach an agreement about them.
Thank you, Luz. And just coming back to this difficulty entailing the technicalities or the technical issues, as you just mentioned, I would like to go back to algorithmic transparency, which is a novelty in law. As you said, only the Spanish law has this type of provisions. But what does the law understand by algorithmic transparency?
Okay, I'm going to speak about the meaning of algorithmic transparency, and I'm going to speak about the specific achievements in this area. Okay. First, I think that we can put two main points in all this plan. The first one is a law regulating algorithmic transparency. And what is this concept means? This law orders companies, all the companies in Spain, not only platform companies, all companies, not only big companies, big, medium, and small companies, all kind of companies that make decisions using algorithms or artificial intelligence systems to inform workers' representatives. This is the concept of the algorithmic transparency. The company has the obligation to inform and sometimes consult the use of algorithms and artificial intelligence for making decisions in the company. This is the meaning in our law. It's not very broad, but it's very important because I think, and we can speak about that later, I think that this is a little step to go a little bit more in industrial democracy, but we can speak about that later. So we have a law, the first law, I think the first law around the world, the first law, of course, which came from the social dialogue, which orders all the companies in my country that make decisions using this kind of devices, algorithms and artificial intelligence to inform workers' representatives about that. This information includes first, this is the first thing, of course, the use of artificial intelligence in company decisions affecting working conditions. Because as you know, many workers don't know anything about this issue. They don't know anything about how is the process of decision of their companies. And now in my country, companies which use this kind of devices must inform about that, about the use of this kind of algorithms or artificial intelligence systems. This is the first one. And the second one, and more importantly for me, is that all companies have to inform about data taken into account by the algorithms. This is the first. And second, their logic of operation. Workers' representatives must understand what is the logic of operation of the algorithms which are using the companies, and this is the law. And for me, this is a very important point because it's the first point. We have a law where all the companies in my country has to inform workers' representatives about these algorithms and these intelligence systems when the use of both affected to the working conditions. This is the condition. Secondly, but for me most important, this regulation, this first step has led to the negotiation of collective agreements where algorithmic transparency is regulated in more detail, a little bit more detail. In Spain, there are sector agreements, multi-employer agreements doing that, and company agreements where the regulation of algorithmic transparency takes place. And this means, and it is important for me, because as you know, I have been studying collective bargaining many years of my life, but this means that at least in Spain, there is no preferential level for collective bargaining on artificial intelligence. We have multi-employer collective agreements speaking about algorithms, and we have company agreements speaking about this issue. So in Spain, there is no preferential level for bargaining on algorithms and artificial intelligence. A very good example of the regulation of sectoral or multi-employer collective agreement is the collective agreement for the banking sector. In this collective agreement, all the companies of this sector, of the banking sector, must inform workers' representatives about one, data used by the algorithms and their operating logic. Two, the two things are in our law, but they are also obliged to make an assessment of the results or fruits produced by the use of artificial intelligence. And this is not in the law. The law is in this case is really limited, because only obliged to companies to inform about data and logic of operation. But in this sectoral agreement, trade unions and employers organizations go a little bit further, and then all companies are obliged to make an assessment of the results produced by the use of artificial intelligence. And of course, this is to prevent, to check that there is no discrimination, no bias, no discrimination in the use of algorithms in the companies. This is an example of the banking sector. But for me, the most important example is a company collective agreement. Is the collective agreement signed by the delivery platform Justit and trade unions, Comisiones Obreras and UGT. Both are the most important unions in Spain, the biggest, but also the most important unions. And in these collective agreements, this collective agreement compels, of course, the company to inform workers' representatives of one, data used by the algorithm and its operating logic, but also prohibits the platform from using, and this is really important, from using data that could be used to discriminate against workers, and specifically prohibit use data about sex or nationality of workers of the company. And this is a step a little bit more further, because this company has to inform workers' representative, both trade unions, data, logic of operation of the algorithm, but also this collective agreement prohibits using data that could be used to discriminate against workers. And this is really important. This means that trade unions need to know data.
What do you mean by that?
Data, because sometimes we are speaking about algorithmics, we are speaking about in artificial intelligence, but we don't know really how many data a company has about the workers. We don't know really. So in this agreement, and now I'm going to speak where all these things happen, but this agreement, for me, has the meaning that this company has to inform workers' representatives about the data the company has about their workers, because they can use data about sex of the workers, about nationality of the workers. So it is necessary to know how many data has the company to try to show that the company doesn't use this kind of data. And this is important. It's
yes,
important.
and Maria Luz, one question: does this prohibition of personal data use and processing only relate to sex and nationality, or goes beyond, for example, in collecting biometrics, the faces or the scan or the photos of the riders, or their localization, or where they live, etc., etc.? I'm trying to link between this collective agreement and the future provisions in the AI Act and the prohibited uses and the use or not of biometric data. If you could say something about that, that would be very helpful.
Yes, this collective agreement doesn't prohibit collect data. This is very important. Collect data, but the scope of this collective agreement is about data which are collected for the employer, but this employer, this platform employer, can't use in the algorithm. It is easy to understand this different situation. It's not about what kind of data can collect the company. The collective agreement doesn't say anything about that. Company can collect, get all kind of data that the company want to do, but the collective agreement prohibit used some kind of data, particularly sex data and nationality data. And it's not the same, I know, it's not the same, it's not the most important thing, because the collective agreement doesn't reach the capacity of the company to collect, to get data, but prohibit the use of some kind of data. Is now a little bit better?
Yes, I think so. I'm also reading another question from the audience, and they ask, if data are related to mainly sex and race, how can the company and the trade union obtain data on those two categories?
Trade union, because, and this is important, and I have to highlight this formula, because in this collective agreement, they create a commission, a special commission called the Algorithmic Commission, which will include a representative of the company and representatives of trade unions, and where all information about data, about algorithms will be analyzed in this commission by representatives of the company and the trade unions. And this is the main in which they are going to understand what kind of data has the company, and what kind of data company can't use. For me, this is the most important thing, because it's the first step, of course, but this means that they create a formula for the governance of the artificial intelligence in the company. And now we are in front of the first steps of that, and all are questions, and we don't have many answers about this commission. But with this commission, they are creating the formula for the governance of the artificial intelligence in the company. And in this commission, they are going to analyze all the data, all the situations about the data, and of course, we are going to evaluate the results of the use of algorithms in the company. It's a very special governance.
And there are so many questions about this workers' data here in the chat. I haven't seen such a lively chat in my AI talks. This is the first time, really. I think your talk is very interesting. So there is a very specific question about workers' data. And is it the provision on the data collection of the workers, or it also applies to the data used to train the AI models that are used? I don't know if you have an answer for that, if it's further specified in the agreement, or if it's something that can be discussed in this new commission that is going to start soon.
No, I would like to highlight that this is a first step. So in this commission, and above all in this collective agreement, is the last collective agreement about Justit, because as you know, Justit has many other collective agreements around the European Union, and this is the last one, I think. So this is a very important issue to highlight. In this commission and this collective agreement doesn't enter in the data which can be get by the company. They don't regulate this first aspect. They don't prohibit to the company, you can get this data. No, this point is not in the collective agreement. It's a very important point, but it's not in the collective agreement. In the collective agreement is important, but it's only the possibility of prohibiting the use of some kind of data, especially the data which can discriminate against workers, and specifically sex data and nationality data.
Is there an evaluation process of this?
It will be an evaluation process of this, because they are now in the first time of this collective agreement, and I think we have a little bit more evaluation and results during 2020 and 23, because they are now creating the commission and creating the rules of this commission. So we are in the very beginning of the process, but it is very important that this commission will know all things about data, all aspects about algorithms decisions, and they are going to evaluate the decisions adopted by algorithms, because they need to know if these decisions are biased or are doing a discrimination against workers. All of this in the same commission.
Right. So it is very important that trade unions can exercise, or trade unions representatives can exercise, workers representatives can exercise their data to access, or the data access right. Yes. That is enshrined in GDPR more generally. How do you see this happening? Do you think they're not going to have some struggles in accessing this possible data that can be used? How do you see this, Luz?
It is difficult to know about that, because if we speak about Spanish, only Spanish, we have an important problem. We have a law, a law very important, a law which is a very important law for me, because it includes a very important aspect in the knowledge about knowledge of the data and algorithmic management, but to access to all this information, it is necessary to have worker representatives in the companies. And we have here a problem. This is the first problem for us, because I don't know if you know that in Spain you have a company has workers representatives institution only when this company has more than 6 or 10 workers. And the majority of the Spanish companies are small companies, and they are they have less than 6 workers. So we have here the first problem, where there is an institution for the workers representatives. We don't this algorithmic transparency doesn't exist. This is the first situation. But in enterprise or companies where worker representatives exist, at this moment, this is not a very important problem. They are assessing to the data, to this data, and they are going, the negotiations are going well. The main problem for me is a technicalities. It's a technical problem, because many workers representatives don't know anything about these issues. So it's difficult. It's difficult for you and for me to speak about algorithms, artificial intelligence, when we came from the industrial relations studies, because we speak about and analyze many other issues, and now we have to take into account that we are going to speak with people who doesn't know about that. So for me, this is the main problem: technicalities, the necessity of training trade unions and employers to do this access without any problem. But if we speak about political issues, at least at this moment, there aren't problems with this right to access.
Okay, Luz, I'm going to go back to the needs of workers' reps and trade unions in order to navigate more easily the areas of data and AI, but I still have a lot of questions about the agreement. And one of our colleagues in Uni Europa is asking, do you see that it is possible for the company to share to third parties the data about workers, including nationality and sex, because these companies are
out of the collective agreement? Yeah, I can understand the question. Really, I don't know. I don't know, because this world is really difficult. It's really difficult to understand all the things. But I know one question, only one question about that. If the algorithm is made out of the company in general, I'm not speaking at this moment about the Justice agreement. In the Spanish experience, if the algorithm is made out of the company, the obligation of inform about this algorithm is also established. This is important because as you know, many companies buy the algorithms out of the company. So in our law says that including the situation when companies out of the company made the algorithm, the information of worker representatives is necessary. But I don't know, really, I don't know if we can find a situation where Justice buy this kind of data, sex and nationality data, for other companies to do all these kind of things. I really don't know. It's not in the collective agreement, but right. I really don't know.
And I have another question here, Luz. Celico asks, are the companies ready to provide these AI logics or the logic of the algorithms to the commission in question?
Mm-hmm. They must do it. They must do it. They must do it. This is the law, and this is the collective agreement. They must do it, and they have to find the solution of this problem if they don't know. So the law, our law, and our collective agreements are really clear about that. Employers have to do it. So if they don't know, if they don't, they are not able to do it, they have to learn how to do it. Don't know do something is not it's not a question for what is the term in English? We speak about no cumplir, doesn't fulfill their obligations.
Thank you, Luz. How can a trade union have more control in the use of the prohibited data? Well, I think that I will rephrase the question from Isabella Vileta. If I may, Isabella, how can the trade union go again? She asks that what's the difference between the prohibition of use these data on sex and nationality and the prohibition of discrimination in general that we have in national EU laws on sex and nationality? What would be the main difference between the collective agreement and the general laws?
Mm-hmm. Yes, this is a really important question. Yes, first, the discrimination, the regulation of discrimination about out of the algorithms must be applied in the algorithm system. This is very important thing. We don't need new rules because we have rules about discrimination, and these rules about discrimination must be applied when we are speaking or we are dealing with algorithmic management in the companies. This is a very important thing. Maybe not we can apply direct discrimination because this is difficult, but we can apply it, and we must apply an indirect discrimination. But this is only an example for me in this collective agreement between Justice and both trade unions, Comisiones Obreras and UGT. They try to avoid two factors, two aspects which can be used for a very important discrimination when we are speaking about delivery platforms. So it's not, there isn't a special difference between the laws and these collective agreements. There isn't this difference. Law about discrimination must be applied in this agreement and in all kinds of agreements about algorithmic management. But in this agreement, they try to avoid two aspects, sex and nationality, which can be used and of course, in fact, they sometimes they are using for discriminating against words. So it's only a way of try to avoid these two aspects, because these two aspects are using commonly for discrimination. So I think this is the meaning of this collective agreement.
And in case there is a violation to this prohibition, what can a union representative do if a company just doesn't respect what it has been signed by the agreement?
Yes, this is a good point. As you know, in Spain, collective agreements are similar to law. Because we have a very special collective bargaining systems, and then our collective bargaining agreements are similar when we are considering the effects of these agreements are similar to a law. So first, all this information has to be analyzed in this commission, algorithmic commission. And then in this commission, they need to know if the obligations adopted in the collective agreement are fulfilled or not. But in Spain, when an employer doesn't apply or is contrary to a collective agreement, it is possible for trade unions to go to the court, labor court, to ask labor judges to oblige to this employer to do what the collective agreement say in the collective agreement. So it is very important because we have enforcement, a very important enforcement of the collective agreements. And in this case, we can, if I don't know, if trade unions think that a company is using this data, which are prohibiting for the use, I think that both trade unions can to go to the labor courts asking judges for say that company stop. This is you can't do this.
And I have two questions, Luz, regarding just precisely the power of the trade unions or the representatives to go to judicial or administrative procedures. I have a listener from Colombia, and she asks if workers or if representatives of platform workers outside a trade union movement or an actual trade union can engage in judicial or administrative procedures on behalf of the platform worker. For instance, can these non-unionized representatives sign collective agreements in Spain? That's a question from a listener in Colombia. And I will link it also with a question regarding precisely our enforcement authorities, the labor inspectorate. What's the role of the labor inspector in Spain to in enforcement the riders law, which is a new one, and these new collective agreements? They are new topics for them, and we're very curious to hear about their capabilities in this domain.
These are really difficult questions, and speaking in English is really difficult to address. Maybe if the one question is from Colombia, maybe I can speak Spanish for this listener from Colombia.
But
I try to combine.
Very difficult because we have 120 listeners listening in English, so we cannot really have.
Okay. So we have a very special, as I told you before, we have a very special collective bargaining system. But when we are speaking about what trade unions can go to defend rights of workers in front of the courts, if we are considering the one collective agreement, only the trade unions which sign this collective agreement can go to the courts. This is the first situation. But when we are considering only rights of the workers without any special collective agreement, for us, for Spanish system, both the trade unions, which is a member, a worker, or the most important trade union in the sector, can go to the courts for defending the rights of workers, including the rights of access to this data. But I have to say that in all our experience about collective bargaining, about algorithmic transparency, there isn't a right of individual workers to access to this data. Only workers' representatives. It's only a collective access to this information. So if we are speaking about go to the court, labor court, when we are consider the rights included in a collective agreement, only the trade unions which sign this collective agreement first. Second, when we are considering in general rights of workers, the trade union which is this worker is member, or the most important union in the sector of in the company can go to defend to the court to defend the rights of workers. And the second one is the role of inspector of labor in enforce the law. It is really important, this role, but I don't know what will be the role in this area in algorithmic management. I don't know. The role of inspection of labor has been very important in the control of the platform work, because as I told you, we have a new law about algorithmic transparency, but also about platform work. And it's a very important law because it's, this law states a presumption of existence of employment relationship between workers and the platform. But I have to say that this law is a result of many things. Of course, social dialogue, but before social dialogue was the role of inspection of labor. The first control of platform workers and platform work and platforms was made by the inspectors of labor in Spain. But I don't know what will be the role in algorithmic transparency. But in any case, in Spain, when there is a law which establishes or states a right for the workers' representatives, and the company doesn't do anything about that, our inspection, Spanish labor inspection, can control the situation and can what is the term in English? Sancionar. Punish the company which is not applying this kind of right. So I think at this moment, I don't know what will be the role, but I can consider that in the future, our labor inspection can punish companies which are not apply this new right to access to the algorithmic information.
And now that you bring into the conversation the new EU or the forthcoming directive on platform work, the Platform Work Directive, that is being negotiated currently by the Council and by the Parliament, the audience is asking, what is the interaction that we will have between the Platform Work Directive in the EU and the Riders' Law in Spain and the collective agreements that the trade unions have signed with employers in Spain?
This is not difficult. I don't know what will be the content of this next European Union directive about decent work or best work in the platform economy. I don't know. I hope, finger crossed, I hope that this directive will be the best. And I hope that this directive will set a presumption of existence or of employment relationship between workers and platforms without any other condition. And this is the main problem at this moment of the negotiation between Parliament and the Commission. But in any case, when the directive is passed, it doesn't matter with the Spanish law, because I think that for me the directive will have a solution which will be coherent with the Spanish solution. So for me, I don't know, really I don't know, but I think that there will be any problem about that. And for me, there will be any problem also about collective agreements. The unique thing I consider about this new directive, in Spain at least, is that in a way to enforce our own law and enforce our own collective bargaining, but there isn't any problem in the relationship between the directive and the Spanish law and Spanish collective agreements.
All right, and just to follow up on this, for those who are not living in Europe, the forthcoming directive on platform work to improve the working conditions of those working for digital platforms is going to be approved hopefully next year within the Swedish presidency, and
or the Spanish.
We'll see.
Maybe a Spanish presidency.
That would be good, though.
Yeah.
In my honest opinion, sorry about that. Normally, it has two main areas: regulating the employment, the presumption of employment, rebuttable, and another big chapter on algorithmic management. But here, our participant 6 is asking, would you recommend that there should be a law in the EU to regulate data processing at work in the context of employment? And he specifies that indeed the General Data Protection Regulation leaves these to the member states. But what would be your idea or recommendation whether there should be a specific regulation at the EU level on data processing in the context of employment laws?
It's really difficult. I don't know, because as you know better than me, the European Union is a very important area, but it's a very every country, each country is different. So I don't know what will be the best solution, but I know something after my experience in the ILO about decent work in the platform economy and about to try to understand well what are the main issues about platform economy and about algorithmic management, which is the best, the ADN of the platform economy. And I think that at this moment, the most important thing is for me is first to try to improve the working conditions and social protection of this kind of workers. And this is the first point and the most important point, to improve the working conditions and the social protection of this kind of workers. Why? Because as we can see in our streets, working conditions are really poor, and social protection in the future will be really poor for this kind of workers. This is the most important thing I learned in my process in the ILO. And when we speak about data protection and algorithmic management and in artificial intelligence, for me, the important thing is that it's not only a question about individual workers. All of these things, it's not only about individual rights and individual workers. And then we need a law about individual rights. We have in the European Union a law about individual rights data protection, all of this kind of things. For me, the most important is, because I believe in industrial relations, I analyze industrial relations, that all of this has a collective aspects, which must be taken into account. So it's not an individual aspect, it's a collective aspect. And finally, it is necessary a collective governance between workers and their representatives, and employers and their representatives of this kind of issues. This is the main lesson for me.
Speaking about governance, what happens if the companies are not compliant? What happens if they violate the rights given by the collective agreements and the new law? Are there sanctions? Are there...
At least in my country, yes. The answer is yes. We have a special model or a special system of collective bargaining. We have a law. We have a special system of collective bargaining, because our collective agreements are like a law, like with the same effects of a law. And in my country, at least in my country, when companies doesn't apply what is stated in the law or in collective agreements, these companies are punished for do this. So for Spanish people, this is not a problem. I don't know in the rest of the countries, but in my country, it's not a problem, because when a company or an employer doesn't apply what is said in a collective agreement, this company or this employer can be punished with a very important sanction. So for Spanish system, this is not a problem.
Oh, that's very important to know, Luz. And in trying to represent workers, or in workers asking for their data, and for the logic involved in the algorithm and all these technicalities, so to speak, data or algorithmic technicalities, the workers' representatives need to sign documents to keep confidentiality of the process and of the information received, especially data or the logic of the algorithm, when they are being informed and consulted?
Not at this moment, not a special document at this moment, but as you know, in our law, in the Spanish law, before all of these issues, we have a statement about the obligation of all our worker representatives of confidentiality when they are dealing with issues, data for the companies. They can't use this information out of the collective bargaining. We have a very special rule in our Estatuto de los Trabajadores, where our law said that our worker representatives have a special obligation of confidentiality of these kind of issues.
Yes, very important to say that, because our audience is also pointing out that platform companies do not provide access to workers' data in the same way in different countries. Sometimes
I know. And this is maybe the main. There are a lot of problems about this issue, but I think that we need to first be patient, but also be strong, because we need to walk around a very special issue. But I think that our trade unions, not only in Spain, around the European Union, trade unions can do it, because they can do things a little bit more difficult than all of these things. They can protect workers every day with collective agreements and collective demonstrations and collective actions. So this is a little bit more, a little bit more further step, but it's the
Right.
same. At the end, it's the same.
Yes, it's the idea is to work together in Europe to have this data access request in a collective manner. That's a good idea. And I have two more questions, if I may.
Two more.
Yes, I have too many more, but
I don't know all the things about this experience. Is the first step. So maybe we can speak again after 6 months, and then we will have a little bit more knowledge about this new experience. But two more questions.
Yes,
again.
please. Another one on the bigger issues that we started with explainability and transparency, which is the point. And there are two concepts that are seen as possible mechanisms to increase algorithmic fairness, algorithmic transparency, and algorithmic accountability.
Mm-hmm.
What would be the right way to do so, to increase it, also from a worker perspective position? And what do you think about ethical auditing?
Ethical.
On the ethical,
Yeah,
because
right.
yes, but in the work relationship or in the working environment, I don't want to say my point of view, but we have these ethical guidelines and proposals for having an ethical auditing of algorithms being used for workers. What is your opinion about that?
Difficult. I have an opinion, and this is my opinion. I think ethics is for the private life. It's a way of the private life. I have my ethic point, you have your ethic point. So for private life, it's really useful, the ethic point of view. But when we are out of the private life, personal life, we need rules, we need a law, we need rules, public rules. Ethic is a good thing for private life, for my life, but not for regulating these issues. It's not enough for regulating these issues. This is my opinion, Luz Rodríguez opinion, only that. Ethic for my life, rules for these complex issues. This is my first point. And the second point, we in Spain, sometimes we are in advance in this kind of issues. I don't know why, because it's the first time in my life. But when we are speaking about ethic, but above all, regulation of algorithmic transparency and all of this kind of concerns, accountability, and all of this, we have a new legal device. It's a soft legal device. It's not a hard legal device, but we had a chart of digital rights, and in this charter, all these things are considered as very important aspects of our new digital rights. It's a soft rule, it's not a hard rule. In general, if you ask me in general, I think that workers, from the workers' perspective, I think that workers need a hard regulation for all these kind of things. In the common struggle between workers and employers, these things don't happen.
Thank you.
Workers need regulation. Workers need the public policies for try to dealing with all these complex issues.
Laws to protect workers. And
yes, again, it's always the same.
How just out of curiosity, how many people in Spain are working in digital labor platforms today?
Yeah, and this is my last answer before to go out. We don't know really. As you know, in Spain, but this is the most common issue around the world. Only Chile only Chile has official statistics. In Spain, we don't have official statistics about how many people are working in the platform economy. But we have two studies, two research studies, where we can see that Spanish is the first country in the European Union in this position about work in the platform economy. As you remember, the second column survey says that Spain has a little bit more than 70%, near 18% of people working sometimes in the platform economy, 80%. But working in the platform economy as a main source of income, I believe that is the 2.6% of our population. Yes, no, it's not really a very important number of workers. But, and this is my last point, but it's not the problem of the platform economy or decent work in the platform economy. It's not, for me, it's not only the number of workers at this moment they are working in the platform economy. At this moment, it's not relevant, this number. The real issue of the platform economy is that this platform economy is trying to risks our main concepts in the labor law. They are trying to put in risk the concept of who is an employee, and they are trying to question who is an employer. And employees and employers are the main pillars of the labor law. If they get move these concepts, they are moving all labor law.
Reshaping labor law, reshaping industrial relations. Thank you. Yes. This brings us to the end of our last episode of 2022. Luz, our audience is extremely interested in the Spanish documents. If you could share the link to the Riders' Law and the link to the Just Eat collective agreement, they will be super thankful. And you, our audience, I have a homework for you. Let us know the topics of interest so we can organize other similar AI talks in 2023. A hearty
thank Okay. Thank you so much, Aida. Thank you so much, European Trade Union Institute, for this interesting talk to you. I'm really, really delighted to be with you, and I hope to see you again in the next year. But I'm going to say something only this in Spanish. Feliz Navidad para todos nuestros oyentes. Hasta pronto.
Muchísimas gracias, Luz. Thank you so much. We hope that you have found today's episode interesting. Happy end of the year. Thank you for tuning into our AI Talks at ETUI. See you next time. Hasta luego. Goodbye.
Adiós. Happy New Year for all of you.